Leading case 12 Mafatlal Industries Ltd etc. v. Union of India etc. In this landmark ruling, the Indian Supreme Court's decision in Mafatlal Industries Ltd etc. v. Union of India etc. set a significant legal precedent in the realm of industrial disputes, taxation, and government regulations. This pivotal case study explores the nuances of rights protection, public interest, and the Establishment Clause, shedding light on the judicial decision-making process and its impact on economic policies. The court judgment in this case has far-reaching implications for constitutional law and has established important legal principles that continue to influence judicial review and legal analysis in India. Join us as we delve into the intricacies of this taxation case and examine the legal framework that has shaped the country's industrial landscape. Hi, I am Advocate Dr. Saurabh Kapoor bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family and social groups to spread this knowledge. Did you know that the Mafatlal Industries case was a landmark decision that reshaped the way we view the balance between economic policies and fundamental rights in India? Mafatlal Industries Ltd v. Union of India is a crucial case in Indian legal history that dates back to 1996. This case involved a dispute between Mafatlal Industries, a leading textile company, and the Union of India. The key players involved were Mafatlal Industries, the Union of India, and the Supreme Court. The 9-judge verdict of the Supreme Court in Mafatlal Industries v. Union of India 1 has decided by a majority of 8-1 as to what rights and remedies are available to a citizen against the state in the matter of refund of unlawfully recovered taxes and imposts. On the one hand, with its seal of approval firmly put on the doctrine of unjust enrichment, the judgment gives a more passive bent and legally less potent content to the right of an assessee to seek refund of taxes illegally and unauthorizedly collected from him. On the other hand, with its strict and unsparing interpretation of the ouster and limitation clauses contained in the statutes in question, viz. the Central Excises and Salt Act, 1944 and the Customs Act, 1962, it seriously erodes and curtails the remedies hitherto available to an assessee for seeking such refund in different courts and jurisdictions. Be that as it may, after a long wait and an arduous battle before the courts and tribunals, the judgment seeks to set at rest a controversy which had racked the imagination of judges and economists throughout the country for the last more than 2 decades. The majority opinion in Mafatlal 1 is rendered by Jeevan Reddy, J., on his own behalf and on behalf of 4 of his brethren. The one totally dissenting opinion is that of S.C. Sen, J. 2 other separate opinions, rendered by Amati, C.J. and Paripornan, J., reflect the views of the 3 remaining judges and more or less concur with the views of Jeevan Reddy, J. However, since the opinion of Jeevan Reddy, J., is the unanimous verdict of as many as 5 out of the 9 judges, it would not really be wrong to treat that opinion as the real and effective judgment in the case, the one which truly declares the law and binds the country on behalf of the Supreme Court. That being so, it may also not be inappropriate to focus attention mainly on that opinion as the cynosure of the present study. The right to refund and the remedy for refund are, indeed, the 2 main streams of Mafatlal 1. On these 2 scores the 9-judge bench approves and disapproves many a celebrated authority of the past and lays down new and important principles. It may not be inappropriate also then to examine some of the unique facets and features of this landmark judgment under the rubrics of the right to refund and the remedy for refund. The right and the remedy, the 2 main streams. The right to refund and unjust enrichment. The doctrine of unjust enrichment, a volatile and elusive judge-made hypothesis till the other day, became a hard and inescapable reality on the statute book in India in 1991 when Parliament accepted it and enacted the Central Excises and Customs Law Act, 1991. The amendments required every assessee seeking refund of an illegally recovered tax to prove that he had not passed on the burden of the tax to the customer or to any other person, for one who had passed on the burden would not be entitled to the refund of money himself. Inevitably, therefore, although the debate on unjust enrichment started much earlier and the question had been pending consideration in the Supreme Court from long before 1991, the amendments of 1991 provided a new legislative edge and exigency to the controversy and occupied the center stage of discussion in Mafatlal 1. The issue of unjust enrichment has not been a matter of concern in this country alone. It has attracted the attention of many a foreign jurisdiction also in recent times. Some foreign decisions approve of the doctrine, some do not. Some others only partly agree with it. The 9-judge judgment in Mafatlal 1 is the Indian answer to a problem which has vexed judges and lawmen alike throughout the liberal economies of the world. The judgment, of course, draws in great measure upon the wisdom and jurisprudence of various foreign court decisions, but it also embellishes and distinguishes itself in the end with an ingenuity and sagacity which is all too native and which has now become synonymous with the extraordinary constitutional thinking and philosophy of this country. On the question of right to refund, i.e. the assessee's substantive right to refund of the illegally recovered tax, the judgment finally bids farewell to the time-honored notion that the right to refund flows automatically as an absolute right from the mandates of Article 265 of the Constitution of India and Section 72 of the Indian Contract Act, 1872, and that it cannot be diluted or affected by any such equitable plea as unjust enrichment, passing on a burden, etc. The new judicial thesis instead rests on the principles of economic and distributive justice enshrined in the preamble and the directive principles of state policy too. It also attaches significance to the unethical consequences which would flow in the fiscal and financial chaos which would follow if no bar of unjust enrichment is applied by the courts before ordering refunds. Article 265 and Section 72 should all be read and understood, says the majority view, in the light of the philosophy and the core values of Constitution and in keeping with equity and good conscience. In the words of Jeevan Reddy, J., the state should refrain from conferring an unearned and unjustifiable windfall upon the assessees. The remedy for refund in three categories of refund claims. On the issue of remedies, all the three substantially concurring opinions in Mafatlal 1, namely, those of Jeevan Reddy, J., Paripurnan, J., as well as Amadi, C.J., divide the situations in which claims for refund may be preferred by an assessee into three categories, viz. First, where the statutory provision under which the tax is levied is itself challenged by the assessee on the ground of being violative of some provision of the Constitution, i.e., an unconstitutional levy. In this class of cases, the claim for refund arises outside the provisions of the Act, for this is not a situation contemplated by the Act. Second, where the tax is collected by the authorities under a statute by misconstruction or wrong interpretation of the provisions of the Act, rules or notifications, or by an erroneous determination of the relevant facts, i.e., an illegal levy. In this class of cases, the claim for refund arises under the provisions of the Act. In other words, these are situations contemplated by and provided for by the Act and the rules. Third, where an assessee, with or without protest and with or without a few litigative steps being taken by him, has ended up paying a tax which he was not legally obliged to pay and which he is seeking refund of at a later point of time on discovering that he had paid the tax on account of a mistaken impression of the law, i.e., a tax paid under a mistake of law. In regard to this category, it is noteworthy that the Supreme Court, on the one hand, refers to the mistake of law as one falling within the meaning of Section 72 of the Indian Contract Act, 1872, and still, on the other hand, confines it to a mistake of law discovered only upon a decision being pronounced by the Supreme Court in some other assessee's case, wherein the Supreme Court holds, in the case of some other manufacturer, that the levy of that kind is not exigible in law. Furthermore, even the Supreme Court decision contemplated as one rendered in a case of unconstitutional levy and not of illegal levy. 3. The noteworthiness is owing to the fact that Section 72 of the Contract Act itself is not limited to such a qualified category of refund claims founded upon the ground of mistake of law. On the basis of such categorization, the majority view proceeds to examine, while acknowledging the true intent and import of the ouster and limitation clauses obtaining in the law concerned, as to in what situations and for what periods of limitation different remedies such as writ under Article 226 or Article 32 of the Constitution of India, or civil suit under the Code of Civil Procedure, or statutory application under the law concerned, are expected to be available or unavailable to an assessee desirous of seeking refund of an illegally recovered tax. While the majority opinion rendered by Jeevan Reddy, J., representing the view taken by as many as 5 learned judges, permits only the remedy of a writ or a civil suit in the case of an unconstitutional levy, it recognizes the maintainability only of a statutory application or a writ in the case of an illegal levy. Whereas no statutory application lies in the former case, a civil suit stands barred in the latter case. And whereas the ordinary rule of limitation relating to discovery of mistake, namely, Section 17 of the Limitation Act, 1963, is applicable in respect of both the remedies permissible in the former case, in the latter case it is the special rule of limitation governing refund claims under the taxing statute concerned which is attracted, and also the writ court is expected to act in conformity with the legislative intent expressed in such statute. The idea of an assessee not pursuing or losing his own case and bringing a refund claim later on in the wake of success of another assessee on the plea of mistake of law is so thoroughly denounced that the question of providing him any remedy does not arise at all, and all remedies are foreclosed to him for The other two partly concurring opinions on the point of remedy for refund, those of Paripornan, J., and Ahmadi, C.J., differ in some minor details from the opinion of Jeevan Reddy, J. being the view taken by only 3 judges. They lose their significance and need not be elaborated upon at length. However, in regard to the majority verdict of Jeevan Reddy, J., it need be noted that some apparent self-contradictions and reversals of logic in the learned judge's rendition do tend to rob an otherwise unquestionably illustrious piece of adjudication of much of its charm. Article 265 is a constitutional source and Section 72 is a statutory origin of the right as well as the remedy. The main argument of the assessee before the 9-judge bench was founded on Article 265 of the Constitution and Section 72 of the Indian Contract Act, 1872, one as a matter of constitutional imperative and the other as a matter of statutory mandate. The argument was founded on both the substantive as well as the procedural sides, the substantive side enfolding the right to refund and the procedural side enfolding the remedy for refund, the two together constituting the two mainstreams of Mafatlal 1. On the substantive side, the assessee sought to derive an indefeasible and unfettered right to refund from the said two provisions untrammeled by any such equitable considerations as the theories of unjust enrichment, necessity of loss or injury for restitution, fiscal chaos, etc. enshrined in any judicial philosophy or statute. On the procedural side, the two provisions were employed to advance the argument that even the ordinary remedy of civil suit with the ordinary and flexible rule of limitation should continue to remain unflinchingly available to him for refund of an unlawfully recovered tax regardless of the ouster, limitation and other procedural clauses in any statute and any objections such as res judicata, finality of orders, etc. Article 265 and the right to refund. The argument of the assessee as to the substantive right of refund claimed by him with reference to Article 265 is best summarized in the concurring opinion of Paripornan, J., as follows. The plea was that Article 265 of the Constitution of India contains a mandate to the effect that no tax shall be levied or collected except by authority of law. It was argued that this is a basic feature of the Constitution and cannot be ignored. If no tax can be collected except by authority of law, the same logic would prevail for retention of amounts collected without the authority of law. If the assessee is denied the refund, the state government could retain the amount illegally collected, and it would amount to violation of the constitutional mandate enshrined in Article 265 of the Constitution. An equitable principle will not hold good against a constitutional mandate. Rejecting the argument of the assessee and agreeing with the counter-thesis on Article 265 advanced by the state, Paripornan, J. held. Persons who have passed on the burden of the levy, middlemen, should not be allowed to profiteer by ill-gotten gains and unjustly enriched. Article 265 of the Constitution is literally interpreted in isolation, and refund ordered, in cases where excise duty has been passed on, it will result in a mockery, totally ignoring the other salient features of the Constitution and the ground realities. As the preamble states, the Constitution was enacted by the people, to secure to all the citizens, justice, political, social and economic. It is fairly settled by the decisions of this court, that the directive principles contained in Part 4 of the Constitution are fundamental in the governance of this country and all organs of the state including the judiciary are bound to enforce those directives. In interpreting the various provisions of the Constitution, the courts have to be realistic and should be alive to the needs of the times. The courts have a responsibility to ensure proper and meaningful interpretation of the directive principles and to adjust or harmonize the objectives enshrined in the preamble, justice, political, social, and economic and the directive principles contained in Part 4, with the individual rights. In the process, it is permissible to restrict, abridge, curtail and in extreme cases, abrogate other rights in the Constitution, if found necessary and expedient, in particular situations. In the light of the above, I hold that Article 265 should be read along with the preamble and Articles 39 and of the Constitution, and so construed in cases where the assessee has passed on the liability to the consumer or third party, he is not entitled to the claim of restitution or refund. The fact that the levy is invalid need not automatically result in a direction for refund of all collections made in pursuance thereto. Jeevan Reddy, J. speaking for the majority voiced the same concerns when he held as follows. Refunding the duty paid by a manufacturer/assessee in situations where he himself has not suffered any loss or prejudice is no economic justice, it is the very negation of economic justice. By doing so, the state would be conferring an unearned and unjustifiable windfall upon the manufacturing community, thereby contributing to concentration of wealth in a small class of persons which may not be consistent with the common good. The preamble and the aforesaid articles do demand that where a duty cannot be refunded to the real persons who have borne the burden, for one or the other reason, it is but appropriate that the said amounts are retained by the state for being used for public good. Indeed, even in an economically neutral constitution, like that of United States of America, such a course has been adopted by the state and upheld by the courts. It would be rather curious, nay ridiculous, if such a course were held to be bad under our Constitution, which speaks of economic and distributive justice, opposes concentration of wealth in a few hands, and when the 42nd Act describes our republic as a socialist republic. The remarks of Jeevan Reddy, J., indeed, are all-encompassing. They lend color and content not only to constitutional provisions but also to all ordinary laws. In the words of the majority judge, key philosophy and the core values of our Constitution must be kept in mind while understanding and applying the provisions of Article 265 of the Constitution of India and Section 72 of the Contract Act, for that matter, in construing any other provision of the Constitution in the laws. Accordingly, we hold that even looked at from the constitutional angle, the right to refund of tax paid under an unconstitutional provision of law is not an absolute or an unconditional right. Article 265 and the remedy for refund. On the procedural side also, the assessee sought to derive from Article 265 a certain amount of ease and flexibility in the matter of filing a refund claim. The argument was that since the claim was one for refund of an unlawfully recovered tax, measures resulting in restriction of remedies available under the law such as ouster of the civil suit, prescription of highly restricted periods of limitation, etc. only contributed to retention, that is to say, collection of tax without any authority of law and, therefore, offended Article 265. By the 1991 Act, further and greater procedural and evidentiary restrictions had been imposed upon an application for refund, for instance, preparation and production of certain documents in a certain manner. The new restrictions were also questioned on a similar reasoning under Article 265. The argument ran as follows. HASA provisions do not preclude the filing of a suit or the filing of a writ petition claiming refund where the tax has been collected contrary to law by virtue of Article 265 of the Constitution, and the question of passing on the burden of duty is totally irrelevant in the matter of refund. Jeevan Reddy, J., in his majority opinion dismissed the argument of the assessee by holding that to make a levy or collection of tax valid under Article 265 all that was required was that such levy or collection ought to be under the authority of a law, but as to whether that law was otherwise valid or not had to be examined with reference to the other provisions of the Constitution. The learned judge observed, Article 265 of the Constitution is declaratory in nature. It says that no tax shall be levied or collected except by authority of law. This no doubt means that taxes collected contrary to law have to be refunded. But where a taxing enactment contains provisions providing for and governing the refund of taxes collected without the authority of law, the validity of such provisions, if and when questioned, has to be examined with reference to other provisions of the Constitution. Article 265 does not itself lay down any criteria for testing the validity of a statute. When it speaks of law, it no doubt refers to a valid law, but the validity of a law has to be determined with reference to other provisions in the Constitution. Based on this reasoning, the court concluded, the said enactments including Section 11B of the Central Excises and Salt Act and Section 27 of the Customs Act do constitute law within the meaning of Article 265 of the Constitution of India, and hence, any tax collected, retained or not refunded in accordance with the said provisions must be held to be collected, retained or not refunded, as the case may be, under the authority of law. Both the enactments are self-contained enactments providing for levy, assessment, recovery and refund of duties imposed thereunder. Section 11B of the Central Excises and Salt Act and Section 27 of the Customs Act, both before and after the 1991 Act, are constitutionally valid and have to be followed and given effect to. On that basis, the various procedural and evidentiary provisions ousting other statutory remedies, fixing short and limited periods of limitation, prescribing the presumption of passing on, and requiring various other formalities to be observed and documents to be filed for the rebuttal of that presumption were found to be beyond reproach on the score of Article 265. In one word, all other remedies apart from the statutory application provided by the taxing statute were permitted to be ousted. However, the court agreed that the statutory bar of the taxing statute cannot operate as an embargo on any constitutional remedy. Thus, even in the case of an illegal levy, the writ remedies under Articles 226 and 32 of the Constitution before the High Court and the Supreme Court respectively were left undisturbed. But the court hastened to add that even the writ courts were expected to take note of the legislative intent manifested in the provisions of the Act and to exercise their jurisdiction consistent with the provisions of the enactment. p. 607 ef. The court made one more exception. It also recognized that a case of unconstitutional levy is a situation not contemplated by the Act and that for such a situation the Act does not provide the consequences. This can be called the right to refund arising under and by virtue of the constitutional provisions, viz., Article 265, the court said. Accordingly, in such a case also it allowed the assessee to take shelter under Article 265 for bringing a refund claim by adopting any remedy available outside the taxing statute, i.e., by way of the writ remedy before the High Court or Supreme Court or even by way of a civil suit. Section 72 and the right to refund. Section 72 of the Indian Contract Act, 1872 requires that a person to whom money has been paid, by mistake, must repay or return it. As noticed above, the majority opinion disapproved the bringing of any refund claim by an assessee on the plea of mistake of law under Section 72 in the wake of success of another assessee in his claim. However, as will be noticed hereinafter, it approved of a refund claim being so brought otherwise, i.e. for reasons other than success of another assessee. Such a claim may be brought by way of a civil suit or writ in a case of unconstitutional levy only. But even in regard to such claims, the right to refund was qualified by the equitable considerations of unjust enrichment. The argument of the assessee was that, in an action for restitution under Section 72 of the Contract Act, the question as to whether the incidence of duty or tax has been passed on is an irrelevant factor. There is no such requirement in the statute. The assessee also argued that there were cases on right to refund of unlawfully recovered tax under Section 72 which had stood the test of time for nearly 4 decades. 5. Repelling the submission of the assessee and to that extent overruling the earlier decisions, Jeevan Reddy, J. held. Whether the right to refund or restitution is treated as a constitutional right flowing from Article 265 or a statutory right arising from Section 72 of the Contract Act, it is neither automatic nor unconditional. Section 72 is a rule of equity. Say that equitable considerations have no place where a claim is founded upon Section 72 is a contradiction in terms. Now, one of the equitable considerations may be the fact that the person claiming the refund has passed on the burden of duty to another. In other words, the person claiming the refund has not really suffered any prejudice or loss. If so, there is no question of reimbursing him. He cannot be recompensated for what he has not lost. The loser, if any, is the person who has really borne the burden of duty. The manufacturer who is the claimant has certainly not borne the duty, notwithstanding the fact that it is he who has paid the duty. Justifying also the presumption of passing on expressly provided by the amendment of 1991, the learned judge further observed. Where such a claim is made, it would be wholly permissible for the court to call upon the petitioner/plaintiff to establish that he has not passed on the burden of duty to a third party and to deny the relief of refund if he is not able to establish the same, since the manufacturer is claiming the refund and also because the fact of passing on the burden of duty is within his special and exclusive knowledge. It is for him to allege and establish that he has not passed on the duty to a third party. This requirement flows not only because Section 72 incorporates a rule of equity but also because both the central excise duties and the customs duties are indirect taxes which are supposed to be and are permitted to be passed on to the buyer. Endorsing that point of view and relying on many foreign and Indian authorities, Puripuran, J. also held in his concurring opinion that restitution presupposes the enrichment of the defendant at the plaintiff's expense, that a person claiming restitution should have suffered a loss or injury himself, that an accounting by the plaintiff is a condition of restitution from the defendant, and that, in cases where restitution is claimed under Section 72 of the Contract Act, on the ground of payment due to mistake of law, the person claiming restitution should plead and prove that he has not passed on the liability to another. That is the nature of accounting in cases falling under Section 72 of the Contract Act. In this context, it is pertinent to note that, constitutionally speaking also, the majority ruled that the economic justice principles of the Constitution must be kept in mind while construing even Section 72 of the Contract Act and, for that matter, any other law of the land. Section 72 and the remedy for refund. The assessee also sought to rely on Section 72 of the Contract Act for availing the remedy of civil suit to press refund claims arising out of mistake of law. The assessee did so notwithstanding the express and specific bar in the taxing statute that no other kind of refund claim shall be entertained apart from the lone 6-month remedy of statutory application provided in such statute and notwithstanding the finality of such remedy. Jeevan Reddy, J., however, dismissed the submission holding as follows. It is necessary to emphasize that the exclusivity of these provisions relating to refund, and conversely the bar to other proceedings created by them, is specific to the subject of refund and is apart from and in addition to the general bar implicit in the Act or expressed in some of its other provisions, as the case may be. Because the Act creates new rights and liabilities and also provides the machinery for assessment and adjudication of those rights and liabilities, a bar to the jurisdiction to civil court arises by necessary implication. The point to be stressed is that the exclusive nature of the refund provisions expressly declared in Rule 11 and Section 11b, at all points of time, is an express and specific one contained in a special statute. It is not the usual finality clause found in several statutes, it is much more. The decisions in Kanhia Law 5, State of MPV. Bilal by 6 were cited in support of this view. Dismissing the argument, the court reasoned. In the face of the express provision which expressly declares that no claim for refund of any duty shall be entertained except in accordance with the said provision, it is not permissible to resort to Section 72 of the Contract Act to do precisely that which is expressly prohibited by the said provisions. In other words, it is not permissible to claim refund by invoking Section 72 of the Contract Act as a separate and independent remedy when such a course is expressly barred by the provisions in the Act, viz., Rule 11 and Section 11b. For this reason, a suit for refund would also not lie. In other words, the court altogether disallowed the plea of mistake of law and a claim for refund of an illegal levy. In fact, it robbed the plea of mistake of law altogether of its significance. As discussed later herein below, the plea of mistake of law used to be of avail in earlier times only in cases of time-barred claims which required the bar of limitation to be removed in accordance with the provisions of the Limitation Act viz., Section 177. But now, as a result of the majority view, since any refund claim in respect of an illegal levy can, in any case, be brought only by means of a statutory application under the taxing statute concerned or by means of a writ petition in the High Court or the Supreme Court within the short and fixed period of limitation prescribed by that statute, there is no particular charm left in the plea of mistake of law. With regard to an unconstitutional levy, however, the plea of mistake of law was still kept alive. It has been seen earlier that the court left open to the assessee either to move a writ petition in the High Court or the Supreme Court or even to bring a civil suit for the refund of such levy under the ordinary law of limitation. Thus, in the context of unconstitutional levy, Jeevan Reddy, J. went on to say, it can be said in such a case that the tax paid has been paid under a mistake of law. Section 72 of the Contract Act may be attracted to such a case and a claim for refund of tax on this score can be maintained with reference to Section 72. Thus, only in the event of the claim being won in respect of an unconstitutional levy the court recognized and allowed a Section 72 suit to be filed with the plea of mistake of law. Further, as regards limitation in such cases the court clarified. In such cases, the plaintiff may also invoke Section 17 of the Limitation Act for the purpose of determining the period of limitation for filing a suit. It may also be permissible to adopt a similar rule of limitation in the case of writ petitions seeking refund in such cases. That is why, while expressing his disagreement with the dicta of Kanhia Law 5 and Bilal by 6 and overruling the same, Jeevan Reddy, J. specifically observed as follows. We must reiterate and emphasize that while dealing with this situation we are keeping out the situation where the provision under which the duty is levied is declared unconstitutional by a court. That is a separate category and the discussion in this paragraph does not include that situation. The result then is that both Kanhia Law 5 and Bilal by 6 remain good law and, in fact, stand affirmed insofar as claims of refund of unconstitutional levy are concerned. On their own facts, indeed, both the cases used to be cases of unconstitutional levy. While in Kanhia Law 5 the state law was found to be without legislative competence, in Bilal by 6 it was found to be in breach of Article 301 of the Constitution. A journey through the majority verdict. The right to refund, achievements and pitfalls. The importance of the judgment in Mafatlal 1 lies not so much in what it did for the immediate disposal of the sundry central excise or customs cases then pending before the court as in what it lays down as a precedent riding high on the pedestal of a 9-judge bench for various future purposes. The wider ramifications of the principle of unjust enrichment as approved and advanced by the court in Mafatlal 1 can be visualized only when the judgment is allowed to emerge from its immediate tax-born cocoon and viewed in the light of myriads of other situations arising in the legal matrix. Viewed in that perspective, the ruling will appear as leaving behind a blazing trail with many a milestone becoming visible only by and by with the passage of time. Some of the visibly important and some not so visible but none too less important features of the judgment need to be noticed before the hour arrives to cope with them. 5 considerations for denying unjust enrichment. As many as 5 broad considerations seem to have weighed with the court in its unjust enrichment discourse. They are: economic justice. The spirit of socio-economic and distributive justice embedded in the preamble and directive principles of the Constitution is an all-pervading influence which should deter the state from conferring an unearned and unjustifiable windfall upon the manufacturing community, thereby contributing to concentration of wealth in a small class of persons which may not be consistent with the common good. That is the core philosophy of the Constitution, which inheres in and imbues every rule, every law and every provision in the Constitution, even Article 265 itself. In other words, no argument in law, whatever be its source or strength and whatever be the situation or setting in which it is made, is potent enough to withstand the egalitarian thrust and altruistic force of the Constitution. The principle is, he who suffers no loss deserves no gain. That principle then is the underlying principle of Mafatlal 1, and it is a good principle to apply as and where required. Restitution. The principle he who suffers no loss deserves no gain is also a basic norm of the law of restitution to which all refund claims belong. A plaintiff seeking restitution is duty-bound to establish that the defendant has been enriched at his expense. A taxpayer who has passed on the burden of tax to his customer can barely hope to do so. While Jeevan Reddy, J. borrowed from the Canadian decision in Air Canada et al. v. Queen and Right of British Columbia et al. 8, the dictum that the law of restitution is not intended to provide windfalls to plaintiffs who have suffered no loss, Puripornan, J. relied on an authority closer home, viz. the Indian Supreme Court decision in Melanchthon v. State of M.P.9, to hold that a person who seeks restitution has a duty to account to the defendant for what he has received in the transaction from which his right to restitution arises. Various other foreign texts and authorities were also cited. However, in principle both the judges reverted to the doctrine of restitution as had been explained more than 200 years ago by Lord Mansfield in the English decision of Moses v. McFarlane 10. Both rejected the contrary principle enunciated in the more recent, nay, contemporaneous, Australian High Court decision of Kapoor of State Revenue v. Royal Insurance Australia Limited. 11 to the effect that the basis of restitutionary relief is not compensation for loss or damage sustained but restoration to the plaintiff of what has been taken or received from the plaintiff without justification. Therefore, quite apart from the issue of refundability of taxes, the law of restitution in India itself has received a new and authoritative look at the hands of the 9-judge ruling. Equity. It is a principle also of equity that he who suffers no loss deserves no gain. The court first ruled that Section 72 is a rule of equity. Thence, Jeevan Reddy, J. concluded. Once it is a rule of equity, it is ununderstandable how can it be said that equitable considerations have no place where a claim is made under the said provision. Now, one of the equitable considerations may be the fact that the person claiming the refund has not really suffered any prejudice or loss. If so, there is no question of reimbursing him. Besides, incorporating the rule of presumption of passing on also as a part of the equitable considerations, the learned judge added. Since the manufacturer is claiming the refund and also because the fact of passing on the burden of duty is within his special and exclusive knowledge, it is for him to allege and establish that he had not passed on the duty to a third party. This is the requirement which flows from the fact that Section 72 is an equitable provision. The moot point is whether the aforesaid principles of equitable considerations, presumption of passing on etc., now that they stand identified under Section 72 of the Contract Act, would not apply also so as to govern all other cases and claims of mistake of law arising under that section. Such a claim may even be a claim between two wholly private parties rather than merely a refund claim in respect of unlawfully recovered taxes against the state. Writ jurisdiction. The court also took into consideration, particularly in the context of claims pending before the writ courts, that the jurisdiction of writ courts was inherently discretionary in nature and that, therefore, a writ court was duty-bound to confront the issue of unjust enrichment in right earnest. In the words of Jeevan Reddy, J. P. power under Article 226 is a discretionary one and will be exercised only in furtherance of interests of justice. This factor too obliges the High Court to inquire and find out whether the petitioner has in fact suffered any loss or prejudice or whether he has passed on the burden. In the latter event, the court will be perfectly justified in refusing to grant relief. The power cannot be exercised to unjustly enrich a person. The above observations, once again, are a recognition of equity and discretion as a latent quality and general attribute of the writ jurisdiction. The observations need not be confined in their application only to a tax refund claim. They are capable of being read in the light of a wider and altogether alien context, in fact, in the context of any money claim coming to the writ jurisdiction of the High Court. Fiscal chaos. The objection of fiscal chaos against restitution had been raised for the first time by the Canadian Supreme Court in the case of Air Canada 8. Jeevan Reddy, J. noticed that in that decision Law Forest, J. had held that even if the airlines could show that they themselves bore the burden of taxes, recovery of ultra vires taxes should be denied because of concerns for the protection of the Treasury and the recognition of the reality that if the tax was refunded, modern government would be driven to the inefficient course of reimposing it either on the same or a new generation of taxpayers to finance the operations of the government. However, the learned judge viewed with some reservation the theory of fiscal chaos as expounded by the Canadian court. He found it paradoxical that while taxes collected under an unconstitutional statute need not be refunded, taxes collected by misinterpreting/misapplying the provisions of a statute ought to be refunded. According to Jeevan Reddy, J., the theory was of little help where the taxpayer had suffered the burden himself and not passed it on to some other person, whether it be a case of unconstitutional levy or illegal levy. Agreeing, therefore, only broadly with the Canadian view in the matter, the learned judge observed, "We, on our part, have to evolve appropriate principles to meet the emerging situations, keeping in mind the development of law in our own country, our own circumstances and above all, our own constitutional philosophy." The learned judge, Jeevan Reddy, J., also noticed that in the United States of America the Congress had for similar considerations even made a law against restitution and that such law had been upheld by the American Supreme Court in United States v. Jefferson Electric Manufacturing Company. 12. As far as Indian precedents go, Jeevan Reddy, J. affirmed the two-judge view on the point in D. Kawasji and Company v. State of Mysore 13 and rejected the 5-judge and 7-judge views negativing fiscal chaos considerations in Kanhia Law 5, Bilal by 6, Aluminium Industries 14 etc. Indeed, the learned judge finally made the doctrine of fiscal chaos a categorical part of his own ruling by stating in proposition of his summary of propositions in para 108 as follows. While examining the claims for refund, the financial chaos which would result in the administration of the state by allowing such claims is not an irrelevant consideration. T is bound to prejudicially affect the public exchequer. In case of large claims, it may well result in financial chaos in the administration of the affairs of the state. These are very wide-ranging considerations. They may come into play in the wake of any other fiscal dispute between the people and the state. They may even succeed in repelling any other kind of challenge to a fiscal law or statute. The universality of the rule of unjust enrichment. The theory of unjust enrichment as enunciated by the Indian Supreme Court in Mafatlal 1 carries with it 3 such characteristics which help in defining the Indian law of unjust enrichment more fully. They may be briefly examined as given below. The bar of unjust enrichment or statute. The Supreme Court recognized the existence of the principle of unjust enrichment as a part and parcel of the Indian legal and constitutional jurisprudence or any new or old statute which may also have been enacted to bring the principle under its statutory cover. Accordingly, while referring to the newly introduced package of the 1991 Act, the learned judge said, "This is the position or 1991 Act, and as we shall point out later, the said Amendment Act has done no more than to give statutory recognition to the above concepts. It needs to be stated in clear terms that the claim for refund by a person who has passed on the burden of tax to another has nothing to commend itself, not law, not equity and certainly not a shred of justice or morality." The learned judge ruled to the same effect when he held in the context of the newly introduced provision of presumption, viz., Section 12b as follows. Section 12b does not create a new presumption unknown till then, it merely gives statutory shape to an existing situation. The obligation to prove that duty has not been passed on to another person is always there as a precondition to claim of refund. It cannot also be said that by giving retrospective effect to Section 11b, any vested rights or substantive rights are being taken away. A manufacturer had no vested legal right to refund even when he had passed on the burden of duty to others. No law conferred such a right in him, not Article 265, nor Section 11b. The bar of unjust enrichment in non-tax matters. The bar of unjust enrichment is not confined in its operation only to tax refund claims. It is operative also in respect of various other money claims against the state. While propounding the Mafatlal doctrine of unjust enrichment, the court in Mafatlal 1 recorded agreement with many decisions of its own earlier and smaller benches, some of which had employed the principle of unjust enrichment in the past for disallowing money claims against the state other than tax refund claims. These decisions had not only been rendered in cases of levies such as market fee, entry tax etc. but, at least, one of them, namely, State of MPV. Mafatlal 15, had even resulted in denial of claims of sugar factories in respect of price of sugar against the government. This last-named decision was, indeed, hailed by Jeevan Reddy, J., as a definite milestone. The Supreme Court in Mafatlal 1 put a 9-judge seal of approval on all such decisions of the past, thereby settling that the law of unjust enrichment in India would apply not only to tax refund claims but also to money claims of all hues and shades against the state where the claimant may have recompensated himself from some other source. The bar of unjust enrichment upon all remedies. Another important clarification which the court made was that the bar of unjust enrichment would apply to any and every form of remedy that a person may adopt under the law. It would apply to the statutory application under the Central Excises or Customs Acts, as the case may be. It would apply to the ordinary remedy of a civil suit. And it also would apply to the constitutional remedy of a writ petition in the High Court or the Supreme Court. The exhaustiveness of the dictum pronounced by the court only underlines once again the universality and unavoidability of the rule of unjust enrichment. The fate of direct taxes. There is also an exception to the rule of universality of unjust enrichment, and that too within the realm of taxation. The rule of unjust enrichment does not apply, as per the ruling in Mafatlal 1 itself, to cases of direct taxation. It applies and can apply only in respect of cases of indirect taxes. Thus, distinguishing the English case of income tax in Woolwich Building Society v. IRC 16, as being of no help, Jeevan Reddy, J. held that, in the case of a direct tax, there can be no question of passing on the burden of tax to others as in the case of an indirect tax. The justification for presumption of passing on in other places in the judgment was also given only in respect of indirect taxes. Finally, in proposition of the summary of propositions in para 108 also the learned judge ruled upon the doctrine of unjust enrichment only by naming indirect taxes. The fate of captive consumption. Not only this, there is reason for optimism even for those interested in the refund of indirect taxes and other exactions. That is so for the reason that even in the case of Mafatlal 1 itself both the majority opinions of Jeevan Reddy, J. and Paripornan, J. have left untouched and undecided the question of applicability of the rule of unjust enrichment insofar as the question of refundability of taxes unlawfully collected on goods meant for captive consumption is concerned. It is, of course, somewhat incongruous that when the two majority judges did record in their opinions their open approval of earlier decisions of the Supreme Court in even non-tax matters, which are far more removed from the implications of a tax refund, they should have declined to decide in the same breath an important and directly connected question of tax refund such as that of refundability of duties collected unlawfully on goods meant for captive consumption. Apparently, the Apex Court anticipated a different kind of argument to be advanced in respect of captive levies on intermediary goods. Perhaps, an argument that excise duty on an article manufactured by a manufacturer for his own internal use and consumption is in the nature of a direct levy on the manufacturer himself. Or, perhaps, that there never is a price tag or label attached to any goods meant for captive consumption so as to be addressed to any customer and, hence, the very question of passing on of tax on such goods to any customer does not arise. Even the 1991 Act, after all, revolves around Section 12A which contemplates documents such as sales invoice etc. stating to the customer the price at which the goods are sold. In the case of goods meant for captive consumption, no such sales invoice can be raised and evidently, therefore, the scheme of the amendment also does not envisage the denial of refund of duty illegally collected on intermediary goods. Little wonder then that Mafatlal 1 bids farewell to captive consumption from a distance. Be that as it may, that may well be the opening of a Pandora's box which might even result in unwinding the theory of unjust enrichment from all those non-tax claims and exactions with which the theory has otherwise been found to be linked by the majority in Mafatlal 1. No unjust enrichment of the state. The judgment of Jeevan Reddy, J. takes care to allay any doubts in the minds of those who may accuse the state itself of getting unjustly enriched on the strength of its doctrine of unjust enrichment. The learned judge explains. The very idea of unjust enrichment is inappropriate in the case of the state, which is in position of parens patria. Later, it is said, state represents the people of the country. No one can speak of the people being unjustly enriched. It was perhaps this thinking that made the court support the idea of the state for retaining the tax for public good. That is how the justification comes eventually for upholding the setting up of the Consumer Welfare Fund under the 1991 Act for depositing all unrefundable excise and customs duties for the welfare of consumers under the control of the state. The learned judge observes. The preamble and the aforesaid articles do demand that where a duty cannot be refunded to the real persons who have borne the burden, for one or the other reason, it is but appropriate that the said amounts are retained by the state for being used for public good. The thin end of the wedge. It is a pity, however, that in the same context of altruistic concern when Jeevan Reddy, J., is shown the utter impracticability and inconvenience of the provision meant for disposal of the refund claims of the real persons who have borne the burden, the learned judge has little or no sympathy for the real sufferer, viz. the consumer, the small and sundry purchaser, the man on the street. Putting an abrupt and anticlimactic finale to the discussion on unjust enrichment, the learned judge chooses to ignore the interests of the very consumer for whose benefit he has allowed the state to hold the illegal levies. The Consumer Welfare Fund, described by the assessee's lawyers variously as a bluff, a colorable device, a dirty trick, a shabby thing and so on, is, indeed, a paradox which threatens to take the very wind out of the sails of the judgment. Faced with such a paradoxical situation, the learned judge has no better sops to offer than these. True it is that there is this practical inconvenience, but it must also be remembered that such claims will be filed only by purchasers of high-priced goods where the duty component is large and not by all and sundry/small purchasers. This practical inconvenience or hardship, as it is called, cannot be a ground for holding that the provisions introduced by the 1991 Act are a device or a ruse to retain the taxes collected illegally and to invalidate them on that ground, assuming that such an argument is permissible in the case of a taxing enactment made by Parliament. To some it may appear to be a volte-face, to some the end of justice, to some the thin end of the wedge. The remedy for refund, the clouds and the confusions. There has been occasion above to highlight the decisive features of the judgment in regard to the three categories of refund claims and the three kinds of remedies provided by law, the three categories being unconstitutional levy, illegal levy and mistake of law, and the three remedies being writ, civil suit and a statutory application. The three remedies discussed in the judgment need no comment. But, the manner in which the refund claims have been divided into three categories as delineated above is far from convincing. Also the ruling of Jeevan Reddy, J., on the point leaves many a doubt to be resolved because of what has been described above as some apparent self-contradictions and reversals of logic. Under categorization on mistake of law. At the very outset, as pointed out above, it is not clear as to how Jeevan Reddy, J. while carving out the category of refund claims founded upon discovery of mistake of law referable to Section 72 confines the category only to a case where the Supreme Court holds, in the case of some other manufacturer, that the levy of that kind is not exigible in law. Section 72 itself does not carry any such qualification as to the circumstances in which and owing to which the mistake in question is discovered. It can even be a mistake discovered out of self-realization, or upon perusal of an author's article or jurist's opinion or, indeed, upon the delivery of a judgment in another assessee's case by merely a high court. Thus, in the first place, the categorization done by Jeevan Reddy, J. with reference to mistake of law is really an instance of undercategorization when viewed from the point of view of Section 72. The three categories, imprecise and overlapping. Moreover, the category of mistake of law, in any case, seems to be somewhat vague and imprecise. The three categories are projected in all the three majority opinions as being mutually exclusive of one another, but, truly speaking, they are incapable of presenting themselves as watertight compartments, each being separate and distinct from the other. Between the first and the second categories, on the one hand, and the third category, on the other, there is bound to be direct and palpable overlapping. It is clear that a tax paid by way of either unconstitutional levy or illegal levy would at all times be a tax paid only in one or the other of the following three situations. 1. Paid with the knowledge of its unlawful nature and under protest. 2. Paid with the knowledge of its unlawful nature but without protest. Paid without the knowledge of its unlawful nature and, therefore, also without protest, that is to say, paid under a mistake of law. Although the first and second categories of refund claims can be expected, at least, in principle, to be distinct and removed from each other, the third category pointed out in the majority opinion does not really unfold a separate and distinct kind of refund claim but one which is only another species of either the first or the second kind of refund claims. The reason is that even a refund claim arising out of mistake of law is founded, after all, upon a mistaken impression either of the unconstitutionality or the illegality of a levy. It would not be a mistake or the ground of unconstitutional levy and also of illegal levy. It is different from the two other categories only in that it is characterized by a late realization of such ground of unconstitutionality or illegality, as the case may be. The late realization marks the end of a period tainted by mistake of law and the beginning of a new era which no more suffers from such mistake. The mistake part of mistake of law is no ground by itself for refund of a tax. The ground at all events is either the unconstitutionality or the illegality which is the subject matter of the mistake. Mistake of law was evolved as a theory and came to be used over the decades as a plea in defense by the assessee only for overcoming the discomfiture arising in cases where his claim was otherwise barred by time, the date of discovery or knowledge of the mistake in such cases either due to self-realization or due to success in another assessee's case provided the point of time from which the period of limitation would run for the former assessee maintaining a refund claim in any court of law or other legal forum. The author of the majority opinion, Reddy J., himself recognizes the raison d'etre of that theory in the context of refund claims of unlawfully recovered taxes while holding that the theory of mistake of law and the consequent period of limitation of 3 years from the date of discovery of such mistake of law cannot be invoked by an assessee taking advantage of the decision in another assessee's case. Thus, whereas the dividing line between the first and second categories of refund claims is the ground on which the refund claim is founded and the purpose of such division is the determination of the jurisdiction in which the respective claims should be preferred, the differentia on which the third category is founded is essentially a circumstance meant for mitigating the delay factor in the filing of the claim. The third category is neither a ground for refund nor, indeed, is it meant for determining the jurisdiction itself. From this point of view, the categorization made by the majority is somewhat inartistic, confusing and uncalled for. Ratio on the mistake of law category, self-contradictory. Even the ostensible purpose behind the introduction of the third category seems to be defeated on account of a curious self-contradiction in the otherwise profound opinion of Jeevan Reddy, J. After all, the whole object of the court in introducing mistake of law as a third and separate category was to pronounce that no assessee shall bring a refund claim upon discovery of such mistake as a result of decision of the Supreme Court in some other assessee's case. In that context, Jeevan Reddy, J. not only approved and acclaimed the Constitution Bench decision of the Supreme Court in the case of Tilachan Motishan v. H.B. Munshi 17 but also ruled in specific terms as follows. Where a person approaches the High Court or the Supreme Court challenging the constitutional validity of a provision but fails, he cannot take advantage of the declaration of unconstitutionality obtained by another person on another ground. This is for the reason that so far as he is concerned, the decision has become final and cannot be reopened on the basis of a decision on another person's case. This is the ratio of the opinion of Hidayatullah, C.J. in Tilachan Motishan 17 and we respectfully agree with it. Not only this, even in proposition of the proposition summarized in para 108, the learned judge specifically held as follows. It is not open to any person to make a refund claim on the basis of a decision of a court or tribunal rendered in the case of another person. He cannot also claim that the decision of the court/tribunal in another person's case has led him to discover the mistake of law under which he has paid the tax, nor can he claim that he is entitled to prefer a writ petition or to institute a suit within 3 years of such alleged discovery of mistake of law. A person, whether a manufacturer or importer, must fight his own battle and must succeed or fail in such proceedings. Once the assessment or levy has become final in his case, he cannot seek to reopen it nor can he claim refund without reopening such assessment/order on the ground of a decision in another person's case. Any proposition to the contrary not only results in substantial prejudice to public interest but is offensive to the several well-established principles of law. It also leads to grave public mischief. Section 72 of the Contract Act, or for that matter Section 17 of the Limitation Act, 1963, has no application to such a claim for refund. However, as opposed to these crystal-clear remarks and unmistakable final proposition of the learned judge, stand his own observations at p. 608 CD running in a completely different direction, viz. Now, the right to refund arising as a result of declaration of unconstitutionality of a provision of the enactment can also be looked at as a statutory right of restitution. It can be said in such a case that the tax has been paid under a mistake of law which mistake of law was discovered by the manufacturer/assessee on the declaration of invalidity of the provision by the court. Section 72 of the Contract Act may be attracted to such a case and a claim for refund of tax on this score can be maintained with reference to Section 72. Contradiction within a contradiction. Even the aforequoted proposition of Jeevan Reddy, J. seems to suffer from a self-contradiction, nay, confusion, of such serious dimension that it threatens to alter radically what may generally be perceived to be the true ratio of the learned judge's judgment. On a broad understanding of the proposition, one may have no doubt left in his mind that the learned judge intends in right earnest to denounce, disapprove and disallow any semblance of effort by an assessee to re-challenge a settled position of tax payability in his own case merely because of success of another assessee in his case. But the true objection of the learned judge seems to be only to assessees freely bringing fresh refund claims while the original assessment order is still standing and without getting that original order set aside. That appears to be the gravamen of the observations. One of the important principles of law, based upon public policy, is the sanctity attaching to the finality of any proceeding, be it a suit or any other proceeding. Where a duty has been collected under a particular order which has become final, the refund of that duty cannot be claimed unless the order is set aside according to law. So long as that order stands, the duty cannot be recovered back nor can any claim for its refund be entertained. But what if the said order falls or is made to fall? What if the assessee applies for a reopening of the order? The learned judge gives profound reasonings for denouncing any claims of the kind, viz., public policy, sanctity attaching to the finality of any proceeding, incongruity of the situation, and so on. But the final words in the final proposition, namely, once the assessment or levy has become final in his case, he cannot seek to reopen it nor can he claim refund without reopening such assessment/order on the ground of a decision in another person's case, tend to completely throw the opinion of the learned judge off the gear. The very soul and purpose of the legal finding and proposition would stand defeated if the reopening of the assessment/order is left open as an escape route to an assessee. This is no mean contradiction or confusion. Indeed, Amati, C.J., in his partly dissenting opinion begs to differ from the opinion of Jeevan Reddy, J. precisely on the point of permissibility of a review or recall of the old assessment/order. Sympathizing with the plight of the luckless assessee and purporting to differ from the apparent and ostensible view of Jeevan Reddy, J., the learned Chief Justice expressed his own point of view as follows. However, in my opinion, since the levy of tax has been held to be unconstitutional, such an interpretation would be unfair to an assessee who had the foresight to discern the unconstitutionality of the provision but was unfortunate in not being able to convince the court concerned of the unconstitutionality of the provision. Considering the gravity of the case, in my opinion, it should be left open to such an assessee to use such legal remedy as may be available to him to have the earlier order reviewed or recalled on the basis of the order made in the subsequent case. If he succeeds, well and good; if he fails, he must take the consequence of an adverse order against him. Amati, C.J., therefore, reels under the impression that Jeevan Reddy, J. does not allow even the reopening of an assessment/order on the ground of another assessee's decision and tends to differ from Jeevan Reddy, J., on the point. But the reality seems to be different. One ground in another ground. Lastly, there is confusion once again in the words on another ground in the remarks made by Jeevan Reddy, J. Where a person approaches the High Court or the Supreme Court challenging the constitutional validity of a provision but fails, he cannot take advantage of the declaration of unconstitutionality obtained by another person on another ground. This is for the reason that so far as he is concerned, the decision has become final and cannot be reopened on the basis of a decision on another person's case. This is the ratio of the opinion of Hidayatullah, C.J. and Tilachan Motishan 10, and we respectfully agree with it. In Tilachan Motishan 17, of course, the Supreme Court did hold that an assessee who moved the High Court but did not come up and appeal to court was not entitled upon the statute being struck down in another assessee's case to plead that the ground on which his petition was dismissed was different and the ground on which the statute was struck down was not within his knowledge and therefore he did not know of it and pursue it in this court. But that was all in the context of an assessee who stopped the contest at the High Court level and that too having been fought on a different ground. Two questions arise from the aforequoted remarks of Jeevan Reddy, J. First, does the learned judge mean to penalize even an assessee who has diligently pursued the battle all the way up to the Supreme Court on a right ground of unconstitutionality and wrongly lost the same? As distinct from the case of Tilachan Motishan 17, Jeevan Reddy, J. has prohibited even an assessee who has fought up to the Supreme Court from reopening the issue. Second, does the qualification of the words on another ground imply that the ire of the learned judge is directed only at those assessees who are not intelligent enough to perceive all the cogent grounds of attack, or is it that he would disallow even those who have lost their cases on the selfsame grounds from reopening the issue? The matter acquires significance, once again, in the light of Amati, C.J.'s partly dissenting opinion because in the very passage aforequoted from pp. 568 grams 569b, the learned Chief Justice fully sympathizes with an assessee who has approached both the Supreme Court and the High Court but has been unfortunate in not being able to convince the court concerned of the unconstitutionality of the provision. Even in such a case of different grounds in play, the learned Chief Justice expressed his approval to allow the luckless assessee to reopen the issue albeit on a different ground. All in all, in brief, the humble submission is that, at least, on the question of remedy of refund, the additional riders and frills put every now and then by Jeevan Reddy, J., in his otherwise profound judgment are far from being perspicacious or productive. They do anything but help in deciphering the true and simple ratio of the decision rendered by the apex court after such a long wait on a question of such colossal magnitude. It is a pity because the judgment of Jeevan Reddy, J., is not only his judgment but the unified and all-important judgment of as many as 5 out of the 9 learned judges constituting the majority. Indeed, it alone is the law laid down by the apex court on the issue for all future guidance. The question, however, is will the judgment itself be able to stand scrutiny of the future? The object of this dissertation is to attempt at calling out the true ratio of what is by all means a difficult judgment. Huge and intricate as it is, the judgment is no less momentous from the point of view of the variety of legal and contentious issues it touches. The complexity of the issues is unavoidable in the very nature of things, but the need to urgently grasp and understand the answers given by the apex court on those issues is particularly felt because of the tendency of the judgment to affect a wide variety of areas pertaining to several other branches of law and jurisprudence. Thus, it is necessary to unravel the mysteries of the judgment and to highlight some of its obfuscations and confusions before the hour of trial finally arrives. From that point of view, emphasis has been laid in this study on the academic and jurisprudential merit of the judgment as a 9-judge precedent of the Supreme Court rather than its adjudicatory importance for the nonce in the bunch of central excise and customs cases decided by it. For the latter purpose, one need go no farther than the format order passed by a 2-judge bench of the court shortly after the main judgment in ACC v. Anam Electrical Manufacturing Company, 5 SCC 744. Mafatlal Industries Ltd v. WOI 5 SCC 536 1997 ELT 247, 111 STC 467 Short Note. Central Excise Act, 1944. S. 11b. Claim for refund of duty, excise, refund, excise duty paid under mistake of law, maintainability of suit or writ petition, unjust enrichment, salutary principle, to be held applicable. Facts. The appellant is a textile mill manufacturing blended yarn. Blended yarn was captively consumed. For the period prior to March 16/17, 1972, the mills paid excise duty on blended yarn manufactured for captive consumption under Tariff Item 18 or 18A of the first schedule to the Excise Act. In a petition, Gujarat High Court held that the levy of the excise duty on blended yarn prior to March 16/17, 1972, under Tariff Item 18 or 18A was ultra vires. The High Court directed refund of the excise duty levied for 3 years prior to institution of the petition, which was instituted on June 5, 1972. The appellant and other mill owners stated that as a result of the declaration of the law as aforesaid by the court, they were not liable to pay excise duty and they had paid the excise duty on the same up to that date under mistake of law. They requested for refund of the excise duty so paid till March 16/17, 1972, stating that such duty was illegally recovered from them. The revenue did not refund the excise duty as claimed. The appellant and others filed suits. The trial court decreed the suits. In the appeals filed by the Union of India against the aforesaid decrees passed by the trial court, the High Court of Gujarat allowed the appeals and set aside the decrees passed by the trial courts, by judgment dated June 4, 1984. It was held that in order to successfully sustain the claim of restitution based on Section 72 of the Contract Act, the person claiming restitution should prove loss or injury to him, and in the cases before them, the excise duty paid on blended yarn was ultimately passed on to the buyer of the fabric, and so the claim for restitution will not lie. In other words, in cases where an assessee has passed on the duty paid by or realized from him, he has suffered no loss or injury, and the action for restitution is unsustainable. Matter was carried to Supreme Court and was ultimately referred to 9-judge bench of the Apex Court. Issue: whether in an action claiming refund of excise duty paid under mistake of law, is it essential for the person claiming such refund to establish loss or injury to him? In other words, in cases where the person from whom the excise duty is collected has passed on the liability or deemed to have passed on the liability, is it open to him to claim refund of the duty paid by him, placing reliance on Section 72 of the Indian Contract Act? View: the 9-judge verdict of the Supreme has decided by a majority of 8-1 as to what rights and remedies are available to a citizen against the state in the matter of refund of unlawfully recovered taxes and imposts. The court relied on the decisions of the courts which have applied the doctrine of unjust enrichment. Reliance was based on State of Madhya Pradesh v. Mafatlal and Shiv Shankar Dal Mills etc. v. State of Haryana and Ors, etc., wherein court held that though refund of fee so collected may be legally due to the traders may be repaid amounts only to the extent that they have not passed on the burden to their customers. To the extent they have passed on, it held, they were not entitled. Held 9-member bench judgment, where burden of duty is not passed on to third party, refund is admissible but no civil suit for refund is maintainable. No automatic refund to be granted under Section 11B of Central Excise Act and Section 27 of Customs Act unless it is proved that duty has not been passed on to third party. Editorial: the term unjust enrichment is not used anywhere in the CGST Act. However, principle is inbuilt under Section 54 of CGST Act. Thus, a refund under Section 54 would have to pass this test. However, only if it can be shown that amount paid is not tax, the said conditions may not apply for seeking refund. A man's true wealth hereafter is the good he has done to his fellow men. Mahatma Gandhi. The case Mafatlal Industries Ltd and Ors v. Union of India and Ors is a landmark judgment by the Supreme Court of India. It primarily deals with refunds of taxes and duties under indirect tax laws and lays down significant principles regarding the doctrine of unjust enrichment in cases involving the refund of taxes. Key details of the case. Citation: 1997 ELT 247, 10 SEC 386. Bench: a 9-judge constitutional bench of the Supreme Court. Core issue. The central issue in this case was whether a person who has paid indirect taxes and then challenges the legality of such payments is entitled to a refund. Specifically, the case sought to determine whether the principle of unjust enrichment would apply to such refunds. Background. Mafatlal Industries and others challenged certain duties and levies imposed under the Central Excise Act and other laws, claiming that they were unconstitutional or otherwise illegal. They sought refunds for amounts already paid, arguing that these payments were made under mistake or coercion. Key principles laid down. 1. Doctrine of unjust enrichment. The court held that any person claiming a refund of indirect taxes must prove that they have not passed on the burden of the tax to the consumers or any other party. If the burden of the tax has been passed on, the claimant is not entitled to the refund as it would result in unjust enrichment. 2. Refund mechanism under tax laws. Refund claims must follow the procedures laid down in the respective statutes. The process generally includes filing refund applications and showing evidence of the absence of unjust enrichment. 3. Equity and public interest. The doctrine of unjust enrichment is based on equity and public interest, as indirect taxes are ultimately borne by consumers. Allowing businesses to recover refunds without considering whether they pass the tax burden on to consumers would disrupt public finance and create inequitable outcomes. 4. Distinction between direct and indirect taxes. The court clarified that this principle primarily applies to indirect taxes, where the tax burden is passed on to consumers. 5. Retrospective and prospective application. The judgment also addressed the applicability of refund claims for taxes paid before and after the introduction of the Central Excise and Customs Laws Act, 1991, which explicitly incorporated the doctrine of unjust enrichment. Impact. This judgment significantly curtailed the scope for claiming refunds for indirect taxes, ensuring that businesses could not profit from refunds where they had already passed on the tax burden to others. It reinforced the principle that equitable considerations must govern public finance and the refund of taxes. This case remains a cornerstone in Indian tax jurisprudence and is frequently cited in disputes involving indirect tax refunds. To understand the significance of this case, we need to dive into its background. Mafatlal Industries was one of the largest textile companies in India, with a substantial workforce and a significant contribution to the country's economy. However, the company was facing severe financial difficulties, which led to a series of events that ultimately ended up in the Supreme Court. The Union of India, on the other hand, was responsible for implementing economic policies that would uplift the country's economy. The government had introduced certain policies that were intended to promote economic growth, but these policies had a significant impact on Mafatlal Industries, leading to the dispute. The stage was set for a battle between the two giants, with the Supreme Court having to intervene and provide a verdict that would have far-reaching consequences for the Indian economy. Moving on, let's discuss the events leading up to the case. The 1980s and 1990s were a tumultuous time for the Indian economy, with the country facing severe economic downturns. The government was under immense pressure to introduce policies that would stimulate economic growth and alleviate the suffering of the common man. One such policy was the Textile Policy of 1985, which aimed to modernize the textile industry and make it more competitive. While this policy had good intentions, it had a devastating impact on Mafatlal Industries, leading to a severe decline in its fortunes. The company was forced to shut down several of its units, resulting in massive job losses and a significant decline in its production levels. The management of Mafatlal Industries was caught off guard, and they were unable to find a way to recover from the losses. The Union of India, on the other hand, was of the view that the textile policy was necessary to promote economic growth and that Mafatlal Industries needed to adapt to the changing economic landscape. As the situation worsened, Mafatlal Industries decided to approach the courts, challenging the constitutionality of the textile policy. The company argued that the policy was violating its fundamental rights, including the right to equality and the right to livelihood. The case made its way to the Supreme Court, which had to navigate through a complex web of legal and economic issues. The court had to balance the needs of the economy with the fundamental rights of the citizens, a delicate task that required immense judicial wisdom. The Supreme Court heard arguments from both sides, with Mafatlal Industries presenting its case against the textile policy and the Union of India defending its policy. The court had to consider several factors, including the economic context of the time, the impact of the policy on Mafatlal Industries, and the constitutionality of the policy. After careful consideration, the Supreme Court delivered its verdict, which would have far-reaching consequences for the Indian economy. The court ruled that the textile policy was unconstitutional and violated the fundamental rights of Mafatlal Industries. This verdict was a significant blow to the government's economic policies, and it sent shockwaves throughout the country. The ruling was hailed as a victory for the rights of citizens and a reminder that the government's powers were not unlimited. The aftermath of the ruling was marked by a renewed sense of hope for Mafatlal Industries, which was able to recover from its losses and regain its position as a leading textile company. The ruling also had a broader impact on the Indian economy, as it forced the government to re-examine its economic policies and ensure that they did not violate the fundamental rights of citizens. The Mafatlal Industries case is a landmark judgment that has had a lasting impact on Indian law. It reaffirmed the Supreme Court's commitment to protecting the rights of citizens and served as a reminder to the government to exercise its powers responsibly. This case is a testament to the power of the judiciary in upholding the Constitution and ensuring that the government does not overstep its boundaries. In conclusion, the Mafatlal Industries case is a significant milestone in Indian legal history, and its impact continues to be felt today. We'd love to hear your thoughts on this case. Do you think the Supreme Court's verdict was justified, or do you think the government's policies were necessary to promote economic growth? Let us know in the comments below. If you're interested in learning more about landmark legal cases, be sure to check out our next video, where we'll be discussing another crucial case that shaped the course of Indian legal history.